Open Carry USMC here. This segment of my ORS videos covers state preemption. In the interest of keeping the length of my videos down, I'm going to just go straight into the subject matter for the video immediately after the pesky legal notice. All the laws I'm going to talk about today can be found at the URL that's on the screen right now. I highly recommend that you go to that URL, you look up these regulations, and you read them. There's not a lot of them. Firearms laws in Oregon are really fairly simple, but it behooves you to do your own research. Don't rely on anyone, not me, not anybody on the internet, nobody but yourself, to do this research, because it's your liberty and your freedom on the line. So ORS 166-170 covers state preemption. Subsection 1 says it accepts as expressly authorized by state statute the authority to regulate in any matter whatsoever sale, acquisition, transfer, ownership, possession, storage, transportation, or use of firearms or any element relating to firearms and the components thereof, including ammunition, is vested solely in the Legislative Assembly. Subsection 2 tells us that except as expressly authorized by state statute, no county, city, or other municipal corporation or district may enact civil or criminal ordinances, including but not limited to zoning, or to regulate, restrict, or prohibit the sale, acquisition, transfer, ownership, possession, storage, transportation, or use of firearms or any element relating to firearms and components thereof, including ammunition. Specifically, it states in the last sentence, ordinances that are contrary to this subsection are void. We'll cover that in the notes at the end of this section. So just what authorities has the state legislature decided to expressly authorize subdivisions of the state to regulate? Well, there's not a whole lot of them, but we're going to cover those next. ORS 166-171 is the authority of county to regulate discharge of firearms. County can adopt ordinances to regulate, restrict, or prohibit the discharge of firearms within their boundaries. Subsection 2 tells us that ordinances adopted under subsection 1 above may not apply to or affect, and I'm just going to run through them, lawful defense of a person or property, lawful hunting, a landowner and guests, public or private shooting range, or a person discharging a firearm in the course of target shooting on public land that is not inside an urban growth boundary or the boundary of a city, if the discharge will not endanger persons or property. And of course the U.S. government is exempt of pretty much everything we've got. ORS 166-172 is the authority of the city to regulate discharge of firearms. And a city can do pretty much what the county can do. And it cannot apply to lawful defense of person or property, public or private shooting ranges, and a few other things. And of course, the federal government is exempt. ORS 166-173 grants authority to cities or counties to regulate possession of loaded firearms in public places. Subsection 1 gives them authority to do that, but public places is only those as defined in ORS 161.015. And in subsection 2 it tells us that ordinances adopted under subsection 1 do not apply to or affect a person licensed to carry a concealed handgun. It's important to note that the courts in Oregon have determined that a public place includes the inside of your car. So if you're in a location that has restricted loaded firearms in public places, having a loaded firearm in your car, which is legal everywhere else in Oregon, is a violation of that city ordinance. So something to keep in mind of. And then there's a few other authorities that the legislature grants. 166-174 prohibits local ordinances that regulate firearms in public building that are rented or leased to a person during the term of the lease. In other words, if someone leases property from a city, the city can't put regulations on there telling them that you can't have firearms. 166-175 allows cities to regulate the purchase of used firearms by pawn shops and secondhand stores, but not private citizens. And in 166-176 grandfathers some restrictions on discharge that were existing when the discharge regulations were taken over by the state. So there's a few things that are important to keep in mind. It's important to realize that according to 166-170 subsection 2, ordinances that are contrary to that subsection are void. So if a local ordinance goes beyond the scope of local authority, the ordinance has no effect. However, that doesn't mean that the local authorities won't try to enforce it on you, which could be an expensive experience. For instance, Portland's requirement that magazines are empty, if you don't have a CHL, goes beyond the scope of their authority and is arguably unenforceable. But no one has challenged this, and it's very likely that someone with a loaded magazine and no CHL will be charged. And only cities and counties can restrict loaded carry. Other government entities such as DMV, a library, schools, etc. are not authorized to do so. 166-173 subsection 2C is if you've got a CHL, you're exempt from all local ordinances. Federal facilities come under other regulations, so keep that in mind. Just because you're in compliance with state law, if you go into federal property, state law still applies, but there's also federal laws that apply, so you need to know that. And the definition of public place in ORS 161.015 has been ruled by the courts to include the inside of your car. So keep that in mind if you don't have a CHL. If you have a CHL, it doesn't really matter because they can't regulate it. I hope you've enjoyed this video. And like I said at the beginning, be sure to check out this URL and look up these rules and regulations on your own. It behooves you. This Open Carry USMC, be safe out there and have a good day.